Hello. I am now back. I finally managed to get hold of the Candace Owens reply to the Macron's opposition to her motion to dismiss their complaint. I say I managed to get hold of it. Really lovely lady Karen managed to get hold of it, so a huge thank you to her, because without her I would not be able to get hold of these filings. Okay, so this is me now. This is my second attempt to record this because my microphone did not pick up the sound for half of the video. So that's a little annoying. I have, if any background noise is heard, I have my little girl next to me as well in bed sleeping. So trying to be quiet, but hey, you might hear some noises. Okay, so let's have a look at this. Introduction. Plaintiffs attempt to muzzle an American journalist through a contrived defamation suit not only tramples the First Amendment, it comprehensively fails as a matter of law. Plaintiffs' opposition cannot correct several dispositive flaws in their pleading. Thus, this court should dismiss with prejudice plaintiffs' amended complaint for 4 reasons. First, this court lacks jurisdiction over Owens. Notwithstanding plaintiffs' belief that Delaware courts may exercise general jurisdiction over any person, anywhere, even if they lack meaningful connection to the state, Delaware statutes and due process principles instruct otherwise. Plaintiffs similarly neglect to provide valid grounds to exercise specific jurisdiction. Second, plaintiff's amended complaint impermissibly adds factual allegations that postdate plaintiff's original pleading in violation of Superior Court Civil Rule 15. Plaintiff's opposition provides no legally cognizable basis for their improper supplementation. Third, plaintiffs cannot overcome defendants showing that Delaware's borrowing statute requires the court to apply France's 3-month statute of limitations. That flaw is fatal to all of plaintiffs' claims. Fourth, plaintiffs' argument that this court should hear this case despite the state lacking any real connection to the case and the plaintiff's concession that Delaware law does not apply misapprehends the law of forum non-convenience. As such, the relevant cryo-made factors favor dismissal. Okay, argument. 1. Plaintiffs cannot meet their burden to establish jurisdiction. Plaintiffs concede it is their burden to establish jurisdiction under both Delaware statutory law and due process principles. However, they fail to meet this burden on any theory. Accordingly, this court lacks personal jurisdiction over Owens. A. No valid statutory basis for jurisdiction. 1. Plaintiffs failed to establish general jurisdiction under Section 3104(c)(4). As shown, Owens is not subject to general jurisdiction under Section 3104(c)(4). Plaintiffs appear to assert that Owens may be sued in Delaware for any tort committed outside the state. That is absurd. To establish general jurisdiction, plaintiffs must demonstrate that Owens has a general presence in Delaware. Plaintiffs can neither make such a showing nor establish any of the limited set of affiliations with a forum that will render a defendant amenable to all-purpose jurisdiction there, which each ordinarily indicate only one place for individuals, their domicile. First, plaintiffs assert the court's general jurisdiction over Owens on the ground that she regularly conducts or solicits business in Delaware because she owns and manages Delaware entities. Not so. Doing business in Delaware is insufficient to confer general jurisdiction in Delaware over a dispute that is otherwise unknown to the state. Second, plaintiffs assert general jurisdiction exists because Owens, through her business entities, contracts with various Delaware entities not headquartered in Delaware. But no authority supports this theory. Merely contracting with Delaware entities is insufficient to establish specific, much less general jurisdiction. Third, plaintiffs' claims that Owens derives substantial revenue from Delaware. Again, this claim is factually unsupported and it improperly conflates Owens with the other defendants. Indeed, plaintiffs do not allege that Owens herself derives any revenue from Delaware. Fourth, plaintiffs do not dispute that Owens has never owned any Delaware real estate, that she does not reside in Delaware, or that she does not conduct business in Delaware. Instead, they rely on her purported contracts, revenue, and ownership of Delaware companies without alleging any conduct by Owens that occurred here. Plaintiffs' claims are also based on statements allegedly made on Owens' podcast, which is broadcast from Tennessee. That is insufficient. As a little footnote here, nor does unrelated litigation in Delaware establish the court's general jurisdiction over Owens. Plaintiffs provide no legal authority to the contrary. Under plaintiff's theory, anyone could sue the Macrons in Delaware for torts the Macrons commit anywhere else in the world because the Macrons have filed this litigation here. That is nonsense. Lastly, plaintiffs argue that anyone who operates a website through a Delaware entity subjects themselves to general jurisdiction here. That is wrong. Maintaining a website that is accessible to anyone over the internet is insufficient to justify general jurisdiction. 2. Plaintiffs cannot demonstrate long-arm jurisdiction. Sections 3104 C1 and 3. Nor can plaintiffs demonstrate long-arm jurisdiction. Plaintiffs' assertion that Owens has not contested plaintiffs' well-pleaded jurisdictional allegations and therefore has conceded them fails. Once Owens moved to dismiss on jurisdictional grounds, it became plaintiff's burden to show that the court has personal jurisdiction over her. Owens need not have anticipated in her opening brief every jurisdictional theory plaintiffs might raise. Regardless, Owens did contest plaintiffs' asserted factual basis for jurisdiction, and plaintiffs' new theories under Section 3104 fail for the same reasons. As to Section 3104 C1, plaintiffs allege that Owens contracts with Delaware entities and sells things consumed in Delaware. As shown, contracting with Delaware entities is insufficient. Further, for this court to exercise jurisdiction under Section 3104 C1, some act must actually occur in Delaware. But here, plaintiffs allege no act by Owens in Delaware. Moreover, the mere formation of a Delaware entity without more is insufficient for a court to exercise jurisdiction. And plaintiffs show no nexus between the formation of the Delaware entities and the cause of action asserted. A nexus exists when the entity's formation is an integral component of the conduct giving rise to the cause of action, or set in motion a series of events which form the basis for the cause of action at issue. In plaintiff's Terramar case, creating the Delaware entity was necessary both to complete the transaction and to give effect to the contract that formed the basis of the litigation. Okay. Here, however, as plaintiffs concede, the entity defendants were formed years before Owens made any of the challenge statements, and their formation has nothing to do with plaintiffs' claims. Accordingly, Section 3104 C1 has no basis for jurisdiction here. Okay. As to Section 3104 C3, plaintiffs alleged Owens caused them reputational and other injury in the state through her tortious conduct of publishing and distributing the series and related ex posts for Delaware citizens and residents to view through Delaware entities. Plaintiffs, however, do not allege Owens committed any relevant conduct in Delaware, and Section 3104C3 jurisdiction exists only if the plaintiff demonstrates that the non-resident defendant has caused a tortious injury in Delaware and such injury was due to an act or omission by the defendant in Delaware. Thus, for a defamation defendant to be subject to Section 3104C3, she or her agent must have been present in Delaware when the article was written or published. Plaintiffs cannot allege that Owens was present in Delaware or acted here, as all publishing and distributing occurred in Tennessee. That Owens's posts and statements are accessible from Delaware or that purchases from Delaware are not prohibited does not support personal jurisdiction. Okay. For example, Cryotherics recently rejected jurisdiction for defamation claims based on a press release published in the Delaware category of a website because defendants must be physically present in Delaware while making defamatory statements to support jurisdiction. Owens was not in Delaware when the statements were made, nor do plaintiffs allege that any Delaware resident was defamed. 3. Plaintiffs' agency allegations do not change the analysis. For the first time, plaintiffs now assert the entity defendants are agents of Owens. Yet in Delaware, a plaintiff has the burden to plead facts, establishing a court's personal jurisdiction in its complaint. And a party cannot amend its pleading through briefing a motion to dismiss. Plaintiffs made no agency allegations in their amended complaint, and the court should reject their attempt to do so through briefing. Plaintiffs' agency argument also fails substantively. Even if the entity defendants were Owens' agents, they still cannot subject Owens to jurisdiction here. Further, plaintiffs have failed to establish agency. Establishing a corporation was acting as the director's agent or alter ego is tantamount to piercing the corporate veil. None of plaintiffs' allegations support such a finding. The Macrons do not allege Owens consented to the entity defendants acting on her behalf in a principal-agent relationship. Moreover, the mere fact that Owens directs these entities does not make them her agents. Even if the entity defendants were Owens' agents, plaintiffs do not allege a single act in Delaware as required by both sections 3104C1 and 3104C3. This contrasts sharply with couples, where the contacts with the state were numerous and purposeful. 4. This court may not consider plaintiffs' alter ego arguments. Plaintiffs claim they can satisfy the long arm by showing that an individual is the alter ego of a Delaware entity with significant contact with the state. This argument fails because the Delaware Court of Chancery has sole subject matter jurisdiction over actions to pierce the corporate veil. This court cannot properly exercise personal jurisdiction under an alter ego theory. This court lacks jurisdiction to consider plaintiffs' alter ego theory. 5. Plaintiffs cannot demonstrate manager consent jurisdiction over Owens, section 18 through 809. I think that's a typo. It's supposed to be section 18 through 109. Yeah. Plaintiffs' section 18 through 109 arguments fail for 5 reasons. First, plaintiffs concede their failure to effect service under section 18 through 109, defeating their jurisdictional argument from the start. Second, plaintiffs cite Hazalt to no avail as Hazalt concerns a different statute. Third, plaintiffs do not explain or allege how their claims deal with the internal affairs of Candace Owens LLC. Fourth, Plaintiffs do not explain or allege how Owens made purportedly defamatory statements in her formal capacity as a manager of Candace Owens LLC. Fifth, plaintiffs cannot distinguish well-settled law in this area. Vici ruled that claims fall outside the scope of Section 18 through 109, where they do not relate to the rights, duties, and responsibilities the defendant owes to the LLC, or in any other way to the internal business affairs of the LLC, or to the running of the LLC's day-to-day operations. Similarly, because plaintiffs challenge Owens' conduct independent of Candace Owens LLC, Section 18 through 109 does not apply. 6. Plaintiffs cannot demonstrate director consent jurisdiction over Owens under Section 3114. Plaintiffs' argument under Section 3114 likewise fails. Plaintiffs did not serve Owens under Section 3114, precluding jurisdiction under that statute. Further, under Section 3114, Owens must be either an officer of a specific type or a director of George Tom Inc. Merely maintaining control over George Tom is insufficient to trigger the statute, and plaintiffs allege only that Owens is George Tom's member or manager. Even if plaintiffs' allegations triggered Section 3114, Hazau is unavailing, as only claims that involve conduct by the non-resident fiduciary using her corporate power will make her a necessary or proper party. Plaintiffs do not allege that Owens exercised her power as George Tom's fiduciary to make the statements challenged here. By contrast, in Hazau, the claims against Hazau involved his actions in his official capacity of negotiating contracts that involved the change of control of a Delaware public corporation, and the contracts chose Delaware law. Thus, even if plaintiffs had served Owens under Section 3114, that statute could not sustain personal jurisdiction over her. Okay. B. Jurisdiction over Owens would not satisfy due process. Even if some statutory basis for personal jurisdiction over Owens existed, due process would not allow jurisdiction here. As discussed in the opening brief, plaintiffs cannot meet the minimum contacts requirement, and every action relevant to plaintiffs' claims occurred in Tennessee. The entity defendant's formation under Delaware law is also not enough to satisfy due process for Owens. First, plaintiffs ignore Delaware law regarding online presence. In Rotblat, now Justice Legros held that knowledge that a website may be viewed in Delaware or accessed by Delaware residents is not sufficient to establish personal jurisdiction. Plaintiffs have made no factual showing, as they must, to prevail that Owens' statements were targeted towards Delaware. That Delaware residents can interact with www.candaceowens.com does not matter. Postings must have specifically targeted readers who are physically located in Delaware, not merely generally directed to readers worldwide. Plaintiffs do not allege that Owens made defamatory statements about a Delaware resident, and accordingly, due process is not satisfied merely by Owens' online presence. Defendants in blogs and other internet sites directed her comments and writings to a worldwide audience, which is inadequate to meet due process requirements. Owens also never spoke about anyone, let alone a Delaware plaintiff, while in Delaware. Second, plaintiffs cannot satisfy Section 18 through 109's three-part test, as the claims here do not focus on Owens' rights, duties, and obligations as a manager of Candace Owens LLC. Third, Hazau makes clear that due process is not satisfied here because, among other things, Delaware's status as the state of incorporation had no rational connection to the cause of action, and the underlying conduct and claims have no rational connection to Delaware. Judge Winston's recent decision in Cryotherics makes a similar point, identifying 8 factors that do not support jurisdiction here, including that the statements at issue were made in Tennessee by a Tennessee resident, and no Delaware law-governed contract is at issue. Because plaintiffs failed to allege any relevant contacts between Owens and Delaware, exercising personal jurisdiction over her would violate due process. Thus, she must be dismissed under Rule 12b-2. Okay, Part 2. The amended complaint should be stricken. As demonstrated in defendant's opening brief, plaintiffs unilaterally filed their amended complaint without leave and impermissibly included allegations that postdate their original complaint. Plaintiffs provide no legally cognizable basis for their improper supplementation, and their new allegations should be stricken as a result. Plaintiffs first argue that leave was not required because their supplemental allegations are indicative of Owens' state of mind at the time of publication and pertain to actual malice. This contravenes Delaware law. As shown, actual malice must be assessed based on what a declarant knew at the time of publication. Here, the original complaint concerned statements occurring between January 31st and February 20th, 2025, whereas plaintiffs' supplemental allegations concern conduct occurring over 6 months later, on September 4th, 2025. Plaintiffs' supplemental allegations cannot, as a matter of law, be relevant to actual malice. Plaintiffs' contrary claim belies common sense, and their legal authority does not support using evidence after an allegedly defamatory publication to establish contemporaneous actual malice. Plaintiffs also claim supplementation was proper because the amended complaint asserts no new causes of action. Rule 15, however, makes no mention of causes of actions, and no Delaware court, including Pella, has cabined Rule 15 as plaintiffs suggest. Finally, plaintiffs argue that a single paragraph of jurisdictional allegations, nestled among several hundred new factual allegations, renders their supplementation proper. Plaintiffs offer no legal authority to support that claim, however, and as shown, plaintiffs' new jurisdictional allegations are futile. At any rate, the balance of plaintiffs' supplemental allegations does not concern jurisdictional issues, violate Rule 15d, and should be stricken. Further, plaintiffs' footnoted request for leave to refile as a supplemental pleading should be denied, both as procedurally improper and as requesting futile relief. Even if properly submitted, the supplemental allegations are legally irrelevant to the claims at issue here. 3. Plaintiffs' claims are time-barred. As shown, Delaware's borrowing statute requires dismissal of plaintiffs' claims because plaintiffs' claims arose in France, and France's 3-month limitations period for defamation is shorter than Delaware's 2-year period. Plaintiffs' claims are thus time-barred. Plaintiffs offer no cognizable grounds on which the court may find otherwise. Further, no policy or doctrine, including the First Amendment, permits plaintiffs to ignore Delaware's borrowing statute, particularly where, as here, dismissal comports with the statute's intended purpose. The borrowing statute requires dismissal. As shown, Delaware courts applying the borrowing statute first determine where the claims at issue arose and then apply the shorter of the potentially applicable limitations period. Plaintiffs do not dispute this analytical framework. Instead, they argue that their claims arose in Tennessee. Plaintiffs are wrong. To determine where a claim arises, Delaware courts rely on 1. The body of case law surrounding the substantive choice of law determinations, and 2. The restatement of conflicts law. Under both the second restatement and case law for multi-state defamation actions, the local law of the state of the plaintiff's domicile applies unless, with respect to the particular issue, one of the other states has a more significant relationship to the occurrence and the parties. That rule applies because defamation produces a special kind of injury that has its principal effect among one's friends, acquaintances, neighbours, and business associates in the place of one's residence. To overcome this presumption, a party must demonstrate that another state has a greater interest in the determination of the particular issue. Here, plaintiffs reside and are domiciled in France. They also serve as the President and First Lady of France, meaning the principal effect of any purportedly defamatory statements would necessarily be felt there, where they and their constituents reside. Indeed, plaintiffs themselves invoke purported damage to the election hopes of Macron in France and complain about the President's discussion of this case with journalists in Paris. Plaintiffs do not dispute that they suffered their alleged injuries in France, instead arguing that a plaintiff's domicile is given less weight in multi-state defamation suits. But plaintiffs mistake Delaware law, which confirms that multi-state defamation claims presumptively arise where the plaintiff resides. To rebut this presumption, plaintiffs were required to show that a jurisdiction other than France has a more significant interest in applying its statute of limitations. Without any legal support, plaintiffs claim Tennessee has a more significant interest than France in applying its statute of limitations because the purportedly defamatory statements were made in Tennessee, where Owens is domiciled. As Delaware courts have repeatedly held, however, a mere discrepancy between the location from which an allegedly defamatory statement was published and plaintiff's domicile will not rebut the presumption that the limitations period of plaintiff's domicile applies. Plaintiff's theory also misapprehends the interests courts consider when determining which statute of limitations applies. Statute of limitation represent a pervasive legislative judgment that it is unjust to fail to put the adversary on notice to defend within a specified period. And although affording plaintiffs what the legislature deems a reasonable time to present their claims, they protect defendants and the courts. Accordingly, because statutes of limitations exist to protect defendants, Tennessee has no interest in exposing its citizen defendants to a longer statute of limitations, let alone an interest sufficient to overcome the presumption that plaintiffs' claims arose when they are domiciled and serve in public office. Plaintiffs' theory that Tennessee has some overriding interest in allowing French plaintiffs to exploit Tennessee's longer limitations period when suing Tennessee citizens belies common sense. France's 3-month limitations period applies here, and it bars all of plaintiffs' claims. Okay. The borrowing statute applies to prevent plaintiffs forum shopping. Unable to overcome the straightforward application of Delaware's borrowing statute, plaintiffs argue its application here would contravene its purpose because plaintiffs are not forum shopping. Plaintiffs' position is absurd. The President and First Lady of France, who have no apparent connection to Delaware, have brought a foreign cause of action that arose in France seeking redress for alleged loss of business opportunities, reputational harm, and diminished election hopes in France. Nevertheless, plaintiffs sued in Delaware, a jurisdiction that 1. Is not where the statements were made, and 2. Has nothing to do with either the statements or the alleged harm resulting therefrom. Plaintiffs also do not allege that they felt any harm in Delaware, or that they have property or business interests in Delaware, or even that they have set foot in the state. Manifestly, plaintiffs chose to bring their claims in Delaware and attempt to ignore the state's borrowing statute to evade France's shorter limitations period. In short, this lawsuit is quintessential forum shopping, the very harm Delaware's borrowing statute is intended to prevent. And in any event, Delaware courts have rejected plaintiffs' argument the borrowing statute has some unwritten requirement that it apply only where the plaintiff is forum shopping. Any greater alteration to the statute, such as limiting its application solely to situations where there is evidence of forum shopping, is the province of the legislator. Okay. Further, Saudi Basic Industries Corp, relied on by plaintiffs, in fact only confirms that Delaware's borrowing statute requires the application of the French limitations period under these circumstances. In Saudi, plaintiff Sabiq, a Saudi Arabian corporation, sought a declaratory judgment that it had not breached a contract with ExxonMobil in Delaware. The court rejected Sabiq's attempt to dismiss ExxonMobil's claim as time-barred under Delaware's shorter statute of limitations. Affirming the trial court's analysis, the Delaware Supreme Court ruled that because Sabiq had brought a declaratory suit in Delaware to avail itself of a shorter limitations period for ExxonMobil's damages claims, applying the borrowing statute to bar Exxon's counterclaims would subvert the statute's underlying purpose. Under the standard scenario, the borrowing statute operates to prevent the plaintiff from circumventing the shorter limitations period mandated by the jurisdiction where the cause of action arose. Here, given the nature of Sabiq's affirmative claim for declaratory relief, ExxonMobil was entitled to assert its overcharged causes of action as counterclaims for damages. In these circumstances, as the trial judge found, the party that was shopping for the most favorable forum was Sabiq, not ExxonMobil. Plaintiffs also ignore the decisions rejecting their theory and limiting Saudi to its facts. A plaintiff seeking declaratory relief to deprive an opponent of otherwise timely counterclaims, a limited exception that is inapplicable here. Here, plaintiff's amended complaint fits neatly into the standard forum shopping scenario described in Saudi. A claim in a Delaware court that 1. arises under the law of France and 2. is barred by that jurisdiction's statute of limitations, but would not be time-barred in Delaware. Thus, Saudi confirms that the Macrons should be prevented from circumventing the shorter limitations period mandated by France. The First Amendment does not change the relevant limitations period. Plaintiffs argue in the alternative that the First Amendment prevents the court from applying France's 3-month statute of limitations. Plaintiffs are incorrect. Although U.S. courts have declined to apply foreign substantive defamation law that contravenes the First Amendment, as shown, the question of which limitation period applies under a borrowing statute is a matter of procedural, not substantive law. Plaintiffs cite no legal authority supporting their claim that the First Amendment bars application of a foreign jurisdiction's shorter statute of limitations because none exists. Applying a foreign limitations period would not violate or even implicate the First Amendment. Under the doctrine of débauchage, choice of law determinations are made on an issue-by-issue basis, with the result that the law of one state may be determined to apply to one issue and the law of a different state to another issue in the same case. Here, applying France's limitations period, a function of Delaware procedural law, also has no bearing on substantive First Amendment protections. If anything, France's shorter statute of limitations affords greater protections to dependent speech, thus enhancing the First Amendment substantive protections. Dismissal under forum nonconvenience is appropriate. Plaintiffs admit Owens is a Nashville resident who records her podcast in the basement of her Nashville home and made the defamatory statements while located in Nashville. Plaintiffs further admit that Tennessee law may apply to their claims because of their significant relationship to Tennessee. Plaintiffs nevertheless argue that none of the cryo-made factors justify dismissal. The opposite is true. The cryo-made factors convincingly favor dismissal. This case has no meaningful connection to the state and does not belong here. Thus, the court should dismiss this action on forum non-convenience grounds. Defendants have met their burden. While the forum non-convenience standard is stringent, it is not meant to be preclusive or insurmountable. Delaware courts are encouraged to review the circumstances of each case to determine whether a defendant has demonstrated overwhelming hardship, and it is well within this court's discretion to dismiss under forum non-convenience when a case involves plaintiffs who are not residents of Delaware, whose injuries did not take place in Delaware, and whose claims are not governed by Delaware. That is the situation here. While plaintiffs emphasize the importance of their choice of forum, those public policy concerns are not as strong where the plaintiff does not reside in Delaware. Nor does the presence of two Delaware entity defendants matter without any meaningful connection between this state and plaintiff's claims. Instead, precedent makes clear that even Delaware corporations and their non-resident officers and directors can avoid facing suit in Delaware, where the connection between the claims at issue and Delaware are attenuated and the defendant corporation faces an undue burden. Okay. The cryo-made factors justify dismissal. The cryo-made factors favor dismissal and plaintiffs' contrary assertions lack merit. First, as plaintiffs concede, the relevant evidence and material witnesses are not located in Delaware, but rather in Tennessee or France. That some potential non-parties with attenuated connections to this case, such as Meta, may be Delaware entities does not alter that fact. Thus, the first cryo-made factor supports dismissal, where, as here, the majority of evidence and proof necessary to litigate plaintiffs' claims is located outside of Delaware. Second, the unavailability of compulsory process in Delaware for witnesses supports dismissal. The court should give no weight to plaintiff's argument that many of the witnesses identified are employees of the Delaware business entities or Owens herself, who controls the business entity dependents. Plaintiffs never identified these many witnesses, their roles at Delaware companies, the allegedly relevant information in their possession, or how they would be compelled to travel to Delaware for trial. Thus, this factor favors dismissal. Third, whether the controversy depends on Delaware law, perhaps the most important factor, strongly favors dismissal. To avoid dismissal under Delaware's borrowing statute, plaintiffs urge the court to apply Tennessee law. But plaintiffs also argue against applying Tennessee law to avoid a forum non-convenience dismissal. They cannot have it both ways. Regardless, under either scenario, Delaware substantive law does not apply to plaintiffs' claims, so this court would be required to decide important issues arising under another jurisdiction's laws. Under these circumstances, dismissal under forum non-convenience is appropriate. Fourth, the cryo-made factor considering whether a related case is pending elsewhere is neutral. Plaintiffs would suffer no prejudice if they sued in Tennessee. Lastly, practical considerations weigh in favor of dismissal. A Delaware court and potentially a Delaware jury should not have to devote time and resources to a matter with no connection to Delaware. This is particularly true where the primary defendant, Owens, is not subject to personal jurisdiction here, making it possible that the parties will litigate overlapping issues in separate fora. Plaintiff's response rests on their mistaken assumption that the formation of the entity dependents in Delaware requires that this case be litigated here. Yet, as explained above, plaintiffs are wrong, particularly in the absence of any connection to Delaware. Taken together, the crime-made factors demonstrate that Delaware is an inconvenient forum to litigate this defamation action, brought by citizens of France against a Tennessee resident regarding statements made in Tennessee that allegedly caused injury in France. Allowing this matter to proceed in Delaware would cause defendants overwhelming hardship. Thus, this action should be dismissed under forum non-convenience. Conclusion: for the foregoing reasons, this case should be dismissed in its entirety. Okay. So when I read the motion to dismiss, I did say I thought it was quite a strong one. It was well written, and I stand by that. Then I read the Macron's opposition, and I thought that was great, and I still stand by that. This is a well-written response to the opposition. I still think that the Macrons made the better argument. I think a combination of a few things is, firstly, they used Owens' own statements, public statements, that she, one, was not going to file a motion to dismiss, and she wanted to go all the way. She wanted to do discovery. I think that was a strong starting point. And I think as well, the argument that the First Amendment does not favour applying law that is less favourable than, in terms of free speech, that is less favourable than the First Amendment itself. That I know that is right, and I think she's going to have a sticking point there. I think the two entities are not going to be dismissed. I'm on the fence about Candace Owens herself as an individual. See, now she did say, well, past litigation, that's not relevant. Technically, it's not relevant, but also she would have heavily had to make the case for why Delaware was the right forum in that litigation. And she didn't just initiate that lawsuit on behalf of the LLCs, her Delaware entities. She did it as an individual as well. And I think that it is relevant. Like she's saying, oh, it's not relevant. It actually is. And that's exactly what the Macron said is, it was to counter her argument that Delaware would cause undue hardship. But the Macrons used that previous litigation to point out that she's been perfectly happy to sue in a Delaware court when it has suited her. And she was, I think when she started the lawsuit, she was a California resident. And when she finished the lawsuit, she was a Tennessee resident. By her own admission, she had never resided in Delaware. And yet, as an individual, not just as the director or the controller of a Delaware entity, Candace Owens, as an individual, elected to use Delaware court to sue another, couple of companies actually. So I still think at this point that the Macrons have the edge. I think for me, they've been more persuasive in their argument. But we will see. I do think this was a good filing. It was a strong argument. So I think it will come down to how the judge rules on this. All right, I am going to wrap up there because I have now taken 2 hours to get through this. But I'm half glad that happened, to be honest, because I think I did this one better on this attempt. So, all right, I will see you all later.